Hello, it's Dmitry again. This is the third video made today. Again, we're going back to Blueprints Psychiatry Chapter 18. Now we're talking about legal issues. This is going to be a relatively short chapter to my understanding, but let's get right into it. Legal issues affect all areas of medicine, including psychiatry. The laws that govern medical practice address physician duty, negligence, and malpractice, as well as patient competence or capacity, consent, and right to refuse treatment. Previous court decisions or precedents are used as the standard by which a given action or inaction is judged. Practitioners should be aware of the pertinent laws of the state in which they practice in order to comply adequately with standards of practice while respecting the rights and duties of their role. Reducing adverse events and legal claims in the healthcare system is known as risk management. Malpractice. The legal definition of malpractice requires the presence of four elements: negligence, duty, direct causation, and damages. Negligence can be thought of as a failure to perform some task with respect to the patient, falling short of the care that would be provided by the average practitioner, the standard of care. Duty reflects the law's recognition of the physician's obligation to provide proper care to his or her patients. This definition of duty or care requires the presence of a doctor-patient relationship. Direct causation requires that the negligence directly cause the alleged damages. Finally, damages, that is to say physical or emotional harm, must in fact be shown to have occurred. In short, malpractice involves the negligence of a duty that directly causes damages. Malpractice claims in psychiatry principally involve suicides of patients in treatment, misdiagnosis, medication complications, false imprisonment, involuntary hospitalization or seclusion, and sexual relations with patients. Informed consent. Informed consent has three elements: information, capacity, and consent. First, appropriate levels of information regarding a proposed treatment, including side effects, alternative treatments, and outcome without treatment, must be provided, the process of informing or disclosing. Second, the patient must have capacity, that is, possess the ability to understand, appreciate, reason, and express a choice, make decisions regarding the risk and benefits of treatment. Having capacity requires more than simply repeating information and necessitates that a person demonstrates comprehension and flexible manipulation of the information in the context of a specific decision. Third, the patient must give consent voluntarily. Important to the concept of volition is the lack of subtle or overt coercion. The elements of informed consent and capacity are depicted in Figure 18.1. True emergency situations are an exception to this rule. Treatments necessary to stabilize a patient in an emergency situation can be given without informed consent. Commonly, the word capacity is used to describe a patient or research volunteer's ability to make a treatment or research participation decision. Competence generally refers to the findings of a judicial or other legal proceeding regarding a person's ability to consent. The two terms are often used interchangeably, however. So remember, capacity is what you are figuring out as a doctor, as a researcher, whatever, saying, can this person make an informed decision? While competence, so that's capacity. Capacity is, can they make an informed decision? You're a doctor, you're a researcher, whatever. Competence is when a judge says, can this person make a decision to consent to something? So think about, for doctors, you're thinking about capacity. For judges, they're thinking about competence. The two terms are often used interchangeably, however. It is important to realize that individuals who have psychiatric disorders such as major depression, mild dementia, or schizophrenia may still retain capacity to consent to treatment or research interventions. All that is required is that a person meets the aforementioned criteria for capacity. So informed consent, going over to information, capacity, and consent, which leads to understand, appreciate, reason, choose. Okay, so this is the elements of informed consent and capacity. What about involuntary commitment? Commitments are generally judicially supported actions that require persons to be hospitalized or treated against their will. Although laws vary from state to state, commitment criteria usually require evidence that the patient is a danger to self, a danger to others, or is unable to care for him or herself. Psychiatrists in most localities have the right to commit a patient temporarily and involuntarily if any of these criteria are met and a diagnosis of a mental disorder is provided. In other words, both a mental disorder and danger must exist. The duration of temporary commitment and the rights of the patient vary by jurisdiction. Patients who have been committed have a right to be treated, and unless they have been declared incompetent, they have the right to refuse treatment. The Tarasov decisions, duty to warn or protect, Tarasov v. the Board of Regents of the University of California, or simply Tarasov, was a landmark case that was heard twice in the California Supreme Court. Tarasov 1, 1976 ruling, held that the therapists have a duty to warn the potential victims of their patients. Tarasov 2, or the second, 1982 ruling, held that the therapists have a duty to take reasonable steps to protect potential victims of their patients. In most localities, this means that the therapist should take reasonable action to protect a third party. If a patient has specifically identified the third party and a risk of serious harm seems imminent. Protection may be defined by specific state law or prevailing legal interpretation, but it may include hospitalizing the patient, altering treatment, warning the intended victim or victims, notifying the police, etc. There are many different legal interpretations, however, of the duty to warn. Such varying interpretations of the physician's responsibilities regarding the balance between confidentiality and protecting others create a great difficulty in psychiatric practice. Because the specific legal requirements vary by state law, it is important to understand the requirements of each jurisdiction, or at least for your jurisdiction. Monotone rule. The insanity defense. Named after a mentally ill man, Daniel Monotone, who attempted to assassinate the Prime Minister of England, I think they mean the UK, in 1843. I think they mean the United Kingdom of Great Britain and Northern Ireland, at that time of Ireland, but whatever. The Prime Minister. Okay. This rule forms the basis of the insanity defense. According to the Monotone rule, a person is not held responsible for a criminal act if, at the time of the act, he or she suffered from mental illness or mental retardation that did not understand the nature of the act or realize that it was wrong. In more recent history, the appropriate use of the insanity defense has been called into question. Some legal theorists argue that the designation guilty but insane to indicate culpability, but at the same time recognize the presence of a mental illness and presumably the need for treatment. Key points. Malpractice consists of negligence, duty, direct causation, and damages. The essential elements of informed consent are information, capacity, and consent. Do they have the information? Do they know what it means? Can they make a reasonable decision that they can consent to? The Tarasov decision led to an expectation that the therapists and doctors take reasonable action to protect persons whom their patients have specifically threatened. The Monotone rule is the basis of the insanity defense. End of chapter 18 regarding the legal issues related to psychiatry. Well, if you got through this video, hopefully it was of good use to you. Have a great rest of your evening or whatever time it might be for you. Thank you and goodbye. Also, this is, by the way, the 5th edition for Blueprints Psychiatry. There's a later, more recent 6th edition out there as well. But anyway, thank you and goodbye.